In September of 2016, a 29-year-old man named Wayne Fella Morrison is loaded into the back of a prison transport van at Yatala Labour Prison in Adelaide. He's cuffed at the wrists and ankles, wearing a spit hood over his face, lying chest down, restrained by several officers around him. The van doors close. For the next 3.5 minutes, nobody outside that van knows exactly what happens inside it. When the doors open again, Morrison is pulled out unconscious, his skin turning blue. He never wakes up. He dies in hospital 3 days later. What happened in that van became known, years later, in the coroner's own courtroom, simply as the black hole, 3.5 minutes, that an entire coronial inquest, running for the better part of 5 years, was never able to fully account for. It would take until 2023 for any kind of formal finding to be delivered at all, and even then, the answers it produced left Morrison's own family with more questions than they'd started with. Welcome to Truth Be Told, Stories from Black Australia. This podcast is recorded on Wiradjuri country, and we acknowledge the Wiradjuri people as the traditional custodians of the land this show is made on. We pay our respects to their elders, past and present. We extend that acknowledgement to all the traditional custodians across the lands, and to any First Nations peoples listening. Today we're talking about Wayne Fella Morrison, a Wiradjuri, Kokatha, and Wirangu man who died in the custody of South Australia's prison system, the years-long fight his family waged just to get basic answers about how, and the law that's since been changed in his name. Quick note before we keep going. This episode discusses a death in custody, physical restraint, and the use of a spit hood. Take care of yourself while you listen. If anything in this brings something up for you, 13 Yarn is a crisis line run entirely by Aboriginal and Torres Strait Islander people, any hour of the day or night, on 13 92 76. Alright, let's go back to the week leading up to his death, because almost everything about it points to a system that had already failed him well before he ever got near that van. Morrison was a Wiradjuri, Kokatha, and Wirangu man, with family connections across both New South Wales and South Australia. He'd been refused bail on an assault charge and was being held on remand, meaning he hadn't been convicted of anything at all, simply waiting for his case to be heard, the exact pre-trial status the Royal Commission into Aboriginal deaths in custody had specifically flagged decades earlier as a population requiring particular care and oversight. Due to overcrowding, he spent part of that week held in police cells at Holden Hill rather than at the prison itself, conditions the coroner, who later investigated his death, described, in her own words, as barbaric and inhumane, closer to solitary confinement than anything resembling appropriate custody, and shocking, in her words, for anyone to be held in during the 21st century. When Morrison was eventually processed into Yatala Labour Prison, the officer who conducted his intake interview wasn't even qualified to carry it out properly. That officer failed to correctly identify Morrison as Aboriginal on his prison file, and never raised what's called a notice of concern about his mental health, a formal flag that would have triggered an assessment by actual medical professionals, an assessment the coroner later found Morrison had been entitled to and never received. Every single one of these administrative failures happened before anything resembling a physical incident had even occurred. On the day he died, Morrison was expecting to appear at the Elizabeth Magistrates' Court by video link, and had told guards he believed he was about to be released on home detention, a detail that stayed with his family ever since, that he likely went into that day expecting to be going home soon, rather than facing any kind of confrontation at all. Hours before that hearing, an altercation broke out between Morrison and two guards inside his holding cell. What followed escalated fast. Up to 12 prison guards wrestled him to the ground in a nearby corridor. CCTV footage played later at the inquest showed him pinned to the floor while his wrists and ankles were cuffed. Officers placed a spit hood over his head, a fabric covering designed to stop a detainee from biting or spitting, and carried him, face down, in what's called a prone position, into the waiting prison transport van. That's where the official record runs out. 5 guards climbed into the back of the van with him. For the next 3.5 minutes, there's no camera footage of the van's interior, and for years, there was no testimony either. Under South Australian law at the time, corrections officers could claim what's called penalty privilege, a legal protection letting a witness at an inquest refuse to answer specific questions if answering honestly might expose them to criminal or civil liability. It's a provision that exists for legitimate reasons elsewhere in the legal system, but applied here to a group of guards who had all been present in the same enclosed space during the exact minutes their colleague died. It functioned less like a safeguard and more like a coordinated wall of silence. Lawyers for the guards involved initially tried to have all of them claim that privilege together, as a group, on the same day, effectively closing off the only window anyone had into what had actually happened to Morrison during those 3.5 minutes. The law itself was changed in South Australia not long afterward, specifically because of how starkly this case exposed the problem, though the change came too late to give Morrison's own inquest the answers it needed at the time. When Morrison was finally pulled from the van, he was already unconscious and turning blue. Resuscitation was attempted. He never regained consciousness and died in hospital 3 days later. The inquest that followed took the better part of 5 years to reach any conclusions at all, and what it eventually exposed went well beyond those 3.5 minutes. The court heard that roughly half the guards on duty at Yatala that day didn't have current first aid training, and that none of them had current CPR certification in a facility responsible for the physical safety of every person held inside it. It heard that a senior guard, Gordon Burnell, the supervisor in charge of the relevant exit that day, left the prison to get lunch after Morrison had already been taken away by ambulance, and when later asked under cross-examination why he hadn't called for an ambulance sooner, told the court that different rules apply inside a prison environment. It heard that staff had been explicitly told not to fill out incident reports, despite a direct order from the prison's own general manager requiring exactly that. It heard that the van used to transport Morrison was put straight back into active service before police ever had the chance to properly inspect it, destroying whatever physical evidence might have remained inside it. It heard that prison management had formed the view that 2 particular officers had run interference in the aftermath of the restraint, language suggesting even some within the department suspected efforts to manage the narrative rather than establish the truth. and it heard officers describing Morrison in the lead-up to his restraint as suffering from something called excited delirium, a supposed medical state involving extreme aggression, unusual strength, and imperviousness to pain, a concept that isn't recognized by the World Health Organization or by the standard diagnostic manual used across psychiatry, and that's been used almost exclusively by law enforcement agencies, mostly in the United States, in the aftermath of exactly this kind of violent restraint, often specifically to explain away deaths that happened during it. When the coroner, Deputy State Coroner Jane Bashir, finally handed down her findings in May of 2023, the result was a genuinely uncomfortable split decision. She found that Morrison's death couldn't be directly attributed to the restraint itself, describing the cause as multifactorial, involving physical exertion, psychological stress, and an underlying heart condition, and made no adverse findings against any of the individual guards, concluding the force used had been reasonable, necessary, and not excessive. At the same time, she was scathing about almost everything surrounding that moment, describing what she called a litany of failings and shortcomings at every single stage of Morrison's time in the department's care, and serious, specific deficiencies in how Yatala's own staff had been trained to handle a major incident. She noted the failure to identify Morrison as Aboriginal on intake. She described the conditions at Holden Hill police cells where he'd been held earlier that week as conditions more akin to punishment or solitary confinement, and said it was shocking that any person would be housed in them. It's a genuinely difficult finding to sit with, a system condemned in comprehensive, specific detail, while nobody working inside that system on that specific day was found personally responsible for anything at all. For Morrison's family, that outcome didn't feel like an answer. His mother, Caroline, had spent years watching witnesses decline to explain themselves at the inquest, hearing one senior prison official balk when directly asked whether he was sorry for what happened to her son, offering only that there had been, in his own measured words, certainly some learnings. Caroline Anderson said publicly that from the very beginning, the department had been, in her description, slippery and sly in how it had handled the matter, right down to the language it chose to use when describing what had happened to her son. The family's barrister pushed the coroner to recommend a fresh, dedicated inquiry specifically into those missing 3.5 minutes, one with the actual power to compel the officers who'd been in that van to speak, with appropriate protection against the legal consequences that had kept them silent the first time around. The family went further, calling for a full royal commission into the broader systemic issues behind Morrison's death, a deliberate, pointed reference to the fact that this country had already run exactly that kind of royal commission into Aboriginal deaths in custody more than 30 years earlier, and still, evidently, not managed to implement enough of its recommendations to prevent this one. One concrete change did come out of the years-long fight over Morrison's death. In September of 2021, South Australia's Parliament unanimously passed what's become known as Fella's Bill, formally criminalising the use of spit hoods in correctional facilities, police custody, and mental health settings across the state. South Australia became the first jurisdiction anywhere in Australia to prohibit them outright. It was a significant, specific, legislative reform that almost certainly wouldn't have happened without Morrison's family spending years forcing his story into public view. For a family that had spent those years fighting simply to be told what happened to their son, it was at least one piece of genuine, lasting change named directly after the man it came too late to save. Morrison's case also sits inside a much wider, unresolved pattern this show has returned to more than once. Since the Royal Commission into Aboriginal Deaths in Custody handed down its findings in 1991, more than 500 Aboriginal and Torres Strait Islander people have died in custody across this country. 500 families have had to navigate exactly the same maze of inquests, privilege claims, resistant institutions, and findings that condemn systems while clearing individuals. The Commission's own recommendations, including ones directly relevant to the kind of situation Morrison found himself in: pre-trial detention in overcrowded facilities, inadequate mental health screening, excessive physical restraint, were meant to prevent exactly this. Almost 3 decades on, the inquest into his death was still citing their absence as part of what went wrong. So that's where we'll leave it for this one. A man held on remand, not yet convicted of anything, kept for part of a week in conditions a coroner would later call barbaric. An intake process so badly handled that nobody even correctly recorded he was Aboriginal or flagged the mental health assessment he was entitled to. 12 guards, a spit hood, and 3.5 minutes inside a prison van that an entire coronial inquest, running for the better part of 5 years, was never fully able to account for. A coroner who found a litany of institutional failure and, in the same breath, found nobody individually responsible for any of it. A law, finally changed, named after a man whose own family is still waiting for the full truth, and a Royal Commission report, more than 30 years old, sitting on shelves with recommendations that would have made a difference here, that still hadn't been properly implemented when this happened. 3.5 minutes. An entire legal and institutional system, and nobody can tell his mother what happened in 3.5 minutes. If something in this one is sitting with you, let it sit for a minute before you reach for the next distraction. That discomfort is doing something useful. Thanks for listening to Truth Be Told. This has been a Three Brothers production. I'll see you next time.